live each day of the week. Come on, let's talk about it. Let's talk about it. What you waiting for? Come and take a seat. Like and subscribe, this is where you wanna be. Cause you know we gon' talk about it. Let's talk about it. Get in here, we in here tonight. So get in here, we in here to vibe.
Hey, everybody. Let me know if y'all can hear me. Hey. Let me know if y'all can hear me. And y'all hit those thumbs up button, please, and thank you. Let's get this video out and about. I only have 49 thumbs up. 49 people remembered to hit the thumbs up button before they came in. So can you guys step out for a second and hit the thumbs up button? Hopefully this won't be too boring. Hold on, I'm trying to turn on my external speaker. All right, here we go. All right, we're going to get right into this. Everybody knows why we're here because I already went live. I did a pre-live to let y'all know that I'm about to come live and break down the Holly Johnson. Well, this is actually the state against Holly Johnson. The state has actually sent up their appeal against the appellate court in regards to the stay of Holly Johnson. They want Holly Johnson to stay in there forever until the trial starts. Of course, the appellate court said, you know, the state did not prove their case. The state didn't like it, so they are going above the appellate court's head. This is the documentation that I'm about to go over. Now, of course, we're praying that the Supreme Court don't even accept it, that they say, no, we're not entertaining this. However, I want to go over the document that was submitted. Okay, thank you, Kim. Thank you. So everything I say on this live stream is based on my opinion only. Y'all know I ain't trying to defame nobody's character, honey. So we will be discussing it all the way down to the final word, okay? And I'll give you guys my opinion on it, all right? So that's what's going to happen. Thank y'all so much for blessing this live stream. And listen, y'all, I told y'all yesterday, I know this is just a little small thing. I told y'all yesterday that that I was, well, you know what? I'm not even gonna talk about it on this live stream. We'll talk about it on another live stream. Let's get to it. I don't want to be no babbler. I want to get to the receipts, honey, because there's a lot. So anyway, there's a 37-page document that the state submitted. Okay, they trying hard in the paint, y'all. When I tell y'all they trying hard in the paint, they trying hard in the paint to try to get this young lady to stay. You would think for a minute that, God damn, are you like, anyway. But the state is doing their job, y'all. I do have to say that the state is doing their job. Personally myself, I don't get involved in these type of cases that much. This is like one of the first ones that I've gotten this deep into when it comes to a court case. So I'm seeing how they do things. Now, if I follow another court case and if they're not going hard in the paint like this, then it's going to have me side-eyeing like, damn, what was the personal interest in this case? But for right now, this may just be what happens, okay? So I can't even really say that this is something that they're doing that's out of the norm, okay? I don't know, but it does seem like the pressure is definitely applied. So anyway, the paperwork is downloaded. We're going to upload it right now so I can show you guys. And we're going to follow along with the document. Now, there was 2 documents, but the first one was only just saying it's a petition for leave to appeal. Okay, so I'm actually going to get rid of that one because actually, no, it's just a certificate. Okay, anyway, I'm going to get rid of that one. So the first page is nothing, you guys, okay? So we're going to get right into the meat of potatoes. Let me look for the thumbs up right quick. Give me a second. Okay. We have 150 people in here. Can we please get to 100 thumbs up, please? And thank you. I need you guys just to step out for a moment and thumbs up this video. Step out for just a moment and thumbs it up. She said they want her to plead out. You know what? Who said that? Somebody just said that. Oh, Audrey. I believe that wholeheartedly. They want her to plead out. I do not believe that they want to go before the courts with this. They do want her to plead out. They want her to sit and get tired of sitting and plead out. Exactly. I believe that too, wholeheartedly. Yes, I do. They want her to take a plea because they know this is an uphill battle. Okay. There's too much evidence out there that shows that this is not going to be easy for the state. I'm not saying it's a slam dunk for Ari, but it's absolutely not easy for the state. Okay. It's not. It's not no cut and dry win. Okay. They're going to have to work for this. So I do believe that they trying to do everything, apply pressure. They want her to plead out so that she could get in her mind. Sometimes they want you to get into your head. All right, let me just start counting my days. I'll be here for 3 or 4 or 5 years, and then I could get out. You know what I'm saying? And that way she won't be anticipating on, damn, I can be released within the next, couple of weeks or so. But nevertheless, they want her to plead. I absolutely agree with that. All right, let me check the thumbs up. And then we may leave here and go to TikTok afterwards, and we'll have a further conversation. Okay, thank y'all so much. Y'all got my thumbs up to 112. I appreciate it. I'm not going to say don't thumbs up the video as you come in. Please do thumbs up the video. I do appreciate it. Show some love. I don't think that we should have that many bush watchers in here, because I mean, as I break this down, I would think that you would want to hear it. So if you do want to hear it, please hit that thumbs up so it could get out to, multiple people or whatever. I do have a goal set of $10, $20 super chats. If you guys can help me reach my goal. I caught myself trying to do the other way and did $52 super chats, and I only got 12 last night. So I was like, well, hell, I might as well just ask for 10. You know what I mean? So anyway, thank y'all for helping me bless this live, or helping me with this live stream. And I also have my coffee up above if you guys want to bless me with a coffee. And yes, I did, Kim. Thank you. All right, let's get into this meat and potatoes, y'all. Let's get into the meat and the potatoes of this live. All right. Ooh, so tiny. Hold on. Let me blow this up a little bit. Let me blow this up a little bit so you guys can follow along with me. I only read a little bit of it, not a lot, just a little bit. Is this going to be big enough? Let me try one more time. Okay, this might be big enough. All right, here we go. All right, I think this is big enough. Is it? Can y'all see this? All right, here we go. So this is the prayer for leave to appeal. We all know that Holly Johnson was charged with first-degree murder. First of all, y'all already know the state of Illinois is appealing to the Supreme Court. And what they are appealing the appellate court's decision. Okay, the appellate court wanted the state to overturn what it is that they had already put in place, ruled on, and that was for her to stay locked up. So they're going above the appellate court's head, all right? And it's the state of Illinois seeks leave to appeal for the judgment of the Illinois Appellate Court, First Districts in People versus Johnson, all right? So People versus Johnson is already a case. Already a case law. Holly is already a case law. So whether she beat this or not, she is already a case law. Case law. Holly Johnson case is a case law already. So the defendant, Holly Johnson, is charged with first degree for the KIN of Romika Blackman by pursuing her several times on the street across from a school where Blackman had just dropped off of her child. And, it's funny that they say across from a school when, in retrospect, we know that it's not across from the school. It's across the street, down the street. But, I guess they try to make things. And let me just say this. Y'all already know Ari is coming back, right? Y'all already know. Matter of fact, I looked up how many days does Ari have to snap back. And give me a moment. I looked that up already before I came live. Give me a second. I think it's 20 days, but let me just check. Ari has up to 21 days. Okay. It says the defense 21 days after May 26. Hold on. So the state had 35 days. Oh, so because the state had 35 days and they had up until May 26 to turn this in, and they turned it in early, the Ari actually have up into June the 16th to respond. But we already know she's not going to take that long to respond. The reason why she has that long is because the state filed early. So she has up until, but I don't think that she will wait until June the 16th to file her response. Okay. Ari doesn't give me the, I want to delay and, make things, draw things out. That's what I'm trying to say. I don't think that she's going to do that. I think that she's going to do it before the 16th of June, but she has until the 16th of June to file her appeal, okay, or her statement, her response. But I do believe that she'll do it way before then, okay? But anyway, let's get back into this. So in my opinion, oh, shoot. Dang, that's early. I ordered my daughter some food and it's here already. Hold on. Give me a second. I don't want to scream in y'all ear. Okay, don't nobody hear the doorbell but me. How was that? Hold on, y'all. Good Lord. I was going to say, don't nobody hear the doorbell but me? Okay. All right, y'all. Sorry. So I think that they say, hold on. She said, Leslie is over there telling her lost followers that Holly shot Romika 7 times and had to correct her statement. The state lied and said several times when it was only 2 times. Wait a minute. You said she's saying she shot her 7 times or several times? Did you mean to say 7 or several? I think you meant to say she's saying that she shot her several times, right, Divinely? Because where she gets 7 from? Good Lord. Can we? Ooh. All right, let's continue. So they're trying to say that, oh yeah, they did say several times. It says by shooting her several times, charge of first-degree murder for Kayan Romika by shooting her several times on the street across from a school where black man had just dropped her child off. Well, I absolutely think that, let me get a color. I might be highlighting some of this. Come on, the freak. Hold on. Why is this box up here? Okay, so I'm gonna be highlighting some things. In my opinion, this right here is kind of misleading, but we have to trust that Ari is going to definitely address all of this, even though I may bring some concerns to it today, just for you guys' awareness. We have to trust that Ari Williams is going to address all of this. Okay, I just think that she's smart to the point that she's going to tackle all of these. So even though it may just be a concern to us today, it's not even a concern. It's just that we may highlight it, but trust and believe Ari is going to take care of this. Okay. So in a 2-to-1 opinion, the appellate court reversed the circuit court's pretrial detention order and remanded the case for imposition of condition of release. So basically, the state is saying it was 2-to-1, that all 3 judges were not on the same beat, okay? That one of the judges did not agree with the appellate court. They actually agreed with the state, okay? So they're saying right here that 2 judges did say that the order should be remanded, okay? The majority held that the state failed to establish by clear and convincing evidence that Holly posed a real and present threat to the safety of any person or the community, and that no condition could mitigate that threat pursuant to the section 110 of this particular act, okay? Leave to appeal, right here. This is where we are. Let me get this out of the way because it's a distraction at this point. All right. Leave to appeal is warranted because the appellate court's decision misconstrues the Pretrial Fairness Act in 2 significant respects that will affect detention proceedings statewide. So why are they saying that? They're saying that because now, what did I tell y'all the last time that we talked? The Supreme Court only gets involved if the case affects statewide decisions. Individual cases like this one, they don't get involved. It has to affect statewide. They had to tie it in to make it seem like this is a statewide issue. This is not just a Holly Johnson versus the people of Illinois versus Holly Johnson. No. Or the state of Illinois versus Holly Johnson. No. This affects the state, okay? So we have to frame it like that so that the Supreme Court will even look at it, okay? Now, this might be a good thing for the state because if they don't, you know, in my opinion, the Supreme Court wouldn't even look at it. So let me let ChatGPT read just that part of why this was such an important thing that the state did right here. Hold on. Let's get to that part.
Absolutely. This document is the state of Illinois asking the Illinois Supreme Court to take the case after the appellate court reversed Quadaja Johnson's pretrial detention order and said she should be released with conditions. The state wants the Supreme Court to step in and clarify how the Pretrial Fairness Act should be applied in serious violent cases like murder. The state is arguing that the appellate court got it wrong when it ordered Quadaja Johnson released before trial.
Okay, I'm gonna stop right there. Now, what is it saying? They want them to step in and they're trying to say that the Pre-Fairness Act should be applied in serious violent cases across the board one particular way, okay? So they're trying to make it a state issue, and that's going to be the uphill battle that Ari Williams will have to face because, again, the Supreme Court wouldn't even look at this if it wasn't a statewide issue. So they're trying to say it's an issue because of the Pretrial Fairness Act that was just released like a few years ago. However, it's been applied in many serious cases since then, okay? But they're just trying it, baby. They're trying their best, all right? So leave to appeal is warranted because the appellate court decision misconstrues the Pretrial Fairness Act in two significant respects that will affect detention proceedings statewide. That's important, statewide. Okay, first, the majority improperly narrowed the dangerousness inquiry under Section 110, okay, by treating the facts that the murder arose from a personal dispute. And the defendant lacks of criminal history, because that's something that they said, as effectively controlling the circuit court assessment of the nature and circumstances of the offense. So they're saying that the majority, two of the judges at the appellate court said that Holly wasn't a danger because this was just a personal dispute, that this wasn't something like she was just randomly targeting someone on the street. This was a personal dispute between one person versus another person, right? And that person is no longer here. So how can she be a threat to anyone else when this was just between her and Romika, which it was. Let's just go there. This was just between her and Romika. This was not a wide, broad thing. She wasn't just out to gun someone down. Oh, let me see who I could just gun down today. No, this was just a personal dispute, a one-on-one personal dispute that was caused by Romika. But we're going to get there. We're going to get there. And then they're trying to also say, and the defendant's lack of criminal history, they're trying to say the appellate court saying Holly doesn't really have a criminal history, so she's least likely to offend again, okay? Now, the state is pushing back and saying the lack of criminal history does not make a person safe or not dangerous. Just because they've never done it before do not mean that they will continue to do it after it's done again, all right? So, in doing so, the opinion conflicted with the plan and the ambiguous language of the PFA, which is the Pretrial Fair Act, and appellate authority, recognizing that the nature and circumstances of a violent offense alone may establish a real and present threat to the safety of the community. Again, they're trying to basically say that the appellate court got it wrong with their decision of trying to overturn the state, saying that she is a real and present threat to the safety of the community. Second, the majority improperly elevated the state's burden at the detention hearing by effectively treating defendants' anticipated self-defense claim as deposition unless affirmatively negated by the state. Thereby, I need to find out what that means because I have no idea what this means right here. Let's get this second part into ChatGPT. Now, I'm going to be honest with y'all. Because I am not a lawyer, I have no problem whatsoever asking for help. Okay, can you explain this? Can you explain this part? And I'd rather do this than to guess or just make up some shit or whatever and mislead you guys down the wrong path. So trust and believe. I have no shame in my game asking for help. Some people, anyway, try by. But let's find out what that means because I have no idea what that second part means. So let's find out together. Okay, here we go. Listen up. Hold on, let me ask for a smooth summary. Hold on, let me just read it.
That part means the state is accusing the appellate majority of treating Khadijah Holly's self-defense argument like it already won the case at the detention stage. Here's the plain English breakdown. The state is saying, open quote, the appellate court acted like once the defense raised self-defense, the state had to fully disprove self-defense before the judge could keep her detained. Close quote. The state says that is wrong because a pretrial detention hearing is not the trial. At trial, if the defendant claims self-defense, the state may eventually have to disprove self-defense beyond a reasonable doubt. But at a detention hearing, the issue is different. The question is not, can the state already prove murder and beat self-defense like we are at trial? The question is whether the state showed enough by clear and convincing evidence that the defendant should stay detained before trial because she poses a real and present threat and no conditions can control that risk. Why is the appellate court made self-defense dispositive? They mean the appellate court gave the self-defense claim too much power too early. Dispositive means it basically decided the issue. The state is saying the majority treated the self-defense claim like, open quote, well, because she may have a self-defense argument, she should not be detained unless the state can already knock that argument down. Close quote. The state argues that this changes the standard from clear and convincing evidence into something closer to beyond a reasonable doubt, which is the trial standard. The state's point IG is supposed to be quicker and more limited. Both sides.
Okay, it's skipping things, you guys. So let me just read it. I'm sorry, it's skipping. So it's not saying everything that is on here. So let's start from the top, okay? It says, this part right here, the state is accusing the appellate court, the two judges, of treating Holly's self-defense argument like it's already won the case at the detention stage. So the state is trying to say the appellate court act like once the defense raised self-defense, in which they have, that the state had to fully disapprove self-defense before the judge could keep her detained, okay? So the state is saying, you can't do that because we're just at pretrial, the pretrial hearing. This is not trial. This is just a pretrial detention hearing, okay? To say whether she stayed locked up before the trial even starts, okay? So the state said that's wrong. They're saying at trial, if Holly claims self-defense, the state may eventually have to disapprove that beyond a reasonable doubt. But at the detention hearing, that issue is different. They do not have to prove it beyond a reasonable doubt at detention hearing. So in my opinion, the state's saying, yeah, we know that we're going to have a hard time proving beyond a reasonable doubt at trial, but we're at detention right now. Let her stay locked up right now, and we will face that issue later in proving it beyond a reasonable doubt, because they know it's all types of doubt in there right now, y'all. All types of doubt. I told y'all, and my ChatGPT told y'all the last few times that there's a lot of reasonable doubt there, okay? So they go on and say, the question is not, can the state already prove murder and beat self-defense like we're at trial? The question is whether the state can show enough by clear and convincing evidence that Holly should stay locked up before the trial because she poses a real and present threat and no conditions can control that risk. Now, the appellate court already told the state with their ignorant asses that they did not meet the burden of that they failed to meet that. But the state doesn't want to accept that. That's why they went to the Supreme Court in the first place, okay? So when the state says the appellate court made self-defense dispositive, they mean the appellate court gave the self-defense claim too much weight too early. So even the appellate court see that this is potentially a strong self-defense case, okay? Now, that's my saying, not the appellate court saying. That's me, all right? Let's continue. Again, the state is saying the appellate court gave the self-defense claim too much power too early. Dispositive means basically dispositive means it basically decides the issue. The state is saying the majority treated the self-defense claim like, well, because she may have a self-defense argument, she should not be detained unless the state can already knock that argument down. Now, I agree with that. Because if she has a self-defense argument, then why is she sitting there? Why is she locked up? Okay? Especially if you're innocent before proven guilty. Why is she there if she has a self-defense argument? All right? All right. Furthermore, the state argues that this changes the standard from clear and convincing evidence into something closer to beyond a reasonable doubt, which is the trial standard, which means what, y'all? Which means the trial is just looking a little bit better for Holly. Why? Because even the state said out their own mouth that they're saying that the appellate court is looking at this closer to beyond reasonable doubt versus clear and convincing evidence. Clear and convincing evidence has to be proven at the detention level. Beyond a reasonable doubt has to be proven at the trial level. The state is already saying that the appellate court saying that there is reasonable doubt, that there is reasonable doubt, okay? So the state argues that this changes the standard from clear and convincing evidence into something closer to beyond a reasonable doubt, which is trial standard. The state point is a detention hearing is supposed to be quicker and more limited. Both sides can present their summaries, their proffers, their witness statements, and their evidence. The judge is not supposed to fully decide guilt, innocent, or self-defense at this stage. The judge is only supposed to decide whether release is safe under the Pretrial Fairness Act. So the state is warning the Supreme Court that if the appellate ruling stands, then any defendant charged with a violent crime could raise self-defense early and force the state to practically try the whole case at detention hearing before detention can be ordered. All right. Now, what are they saying? They saying if the appellate court is allowed to stand on, well, a self-defense case has been raised, then everybody that come and say it was self-defense, then they could potentially be released because, you know, at that point, they're saying, well, if it's self-defense, then there's no need for them to be locked up. That's what the state is arguing. This is why they say it conflicts with the structure, the purpose, and the expedited nature of the detention's proceedings. In other words, detention hearings are supposed to move fast and answer a limited amount of questions. They're not supposed to become a full trial before the actual trial. All right. So what is the state really saying, y'all? The state is basically saying that the appellate court jumped too far ahead. Okay. They are saying that the self-defense is a trial issue, not a detention hearing issue, not something the state has to fully defeat at detention hearing. At this stage, the state is only saying that they have to show clear and convincing evidence that she is a danger that no conditions will mitigate, okay? No conditions will work for her. The state is arguing that the appellate court treated her self-defense claim like a get out of detention card, unless the state could already disprove it like they have to at trial. All right. That is what this second part of their argument is about. Now, in my opinion, and I want to ask ChatGPT this, in my opinion, let me just ask, and then I'll tell you my opinion. So does this potentially means the state knows reasonable doubt is already present and they will have an uphill battle? Okay, I said, so does this potentially mean the state knows that there is some potential reasonable doubt and that potential reasonable doubt is already present and that they will have an uphill battle at trial? Okay, I asked that because that's basically what the hell they're saying, you guys. That's basically what the hell they're saying. They're saying the appellate court is treating this closer to reasonable doubt, beyond reasonable doubt, than they are clear and convincing evidence. So the state is already saying, I know we have to be able to, win this case beyond a reasonable doubt, but right now we're not there. So let's listen up.
Yes, potentially, but I would not say it as the state knows they have reasonable doubt. I would say it more carefully. The state knows the defense already has a self-defense argument that could create reasonable doubt at trial, and they do not want that trial issue controlling the detention decision right now. That paragraph is basically the state admitting indirectly that self-defense is going to be a major issue in this case. Mm-hmm. They are saying, even if she has an anticipated self-defense claim, the appellate court should not treat that claim like it already defeats detention. Mm-hmm. The state understands they may have an uphill battle on self-defense at trial because the defense has several points to work with. Johnson had previously sought a stalking no-contact order against Blackmon. Mm-hmm. The defense says Blackmon had threatened Johnson before, including threats to kill her. The defense says Blackmon was the aggressor. Mm-hmm. The defense says Johnson's baby was in the car. Johnson stayed at the scene and cooperated. There are competing witness accounts. Those facts can absolutely give a jury something to wrestle with. And if even one juror believes Johnson may have reasonably feared for herself or her child, that can become a problem for the state at trial. Mm-hmm. But the state's response is, that is for trial, not detention. Mm-hmm. Their argument is not necessarily we have a weak case. Their argument is, open quote, the defense can argue self-defense later, but right now the question is public safety. The court should not require us to fully disprove self-defense at this early detention hearing, close quote. So for your live, I would phrase it like this, open quote. This tells me the state knows self-defense is not some throwaway argument in this case. Mm-hmm. They know the defense has enough there to make it a real trial issue. But what the state is saying is, do not make us try the whole self-defense case at a detention hearing. That is for the jury. Right now, the question is whether the facts of this shooting show dangerousness under the Pretrial Fairness Act, close quote. That is the cleanest and most accurate read.
Okay, again, I know what ChatGPT's saying, but I'm saying that that the state knows that there is some reasonable doubt and they got an uphill battle. Okay, they know that that self-defense claim that Ari is raising for Holly is strong. It ain't just no little small thing. Okay, there's a lot of things there that presents this as self-defense. One of the main reasons is Ramika is the one that pulled up on them. Ramika is the one uninvitedly pulled up, Buster Huey, and pulled up on them. Beyond all the other shit, Holly was not the aggressor. Holly did not start this shit. Ramika did. Okay, let's continue. All right, so the next one is accordingly, we're right here, you guys. We're right here. All right. So accordingly, this court should grant leave to appeal to clarify whether the nature and circumstances of a violent offense may support a finding of dangerousness, whether the offense arose from a personal dispute, and whether the state must conclusively disprove a defendant's anticipated self-defense claim at pretrial detention hearing before detention may be ordered. Under the clear and convincing evidence standards, resolution of these issues is necessary to ensure uniform applications of the Pretrial Fairness Act and to prevent the detention statute from being judicially narrowed in a manner inconsistent with the legislative intent. Okay, so let's go on. So, statement regarding the judgment. On April the 20th, 2026, the appellate court issued its decision, People versus Johnson. So on April the 24th, the appellate court granted the state's motion to stay the mandate pending the filing and disposition of the petition for leave to appeal. The petition for leave to appeal is timely filed. Okay, so now they're just saying we filed it. Okay, so now here we go. Points relied upon in seeking review. The appellate court erred in reversing the circuit court's detention order because its decision conflict with the plain language of Section 110 of the Pretrial Fairness Act and decisions of other appellate districts by improperly deeming the facts that the murder arose from a personal dispute. So that's what they're trying to say. Personal dispute as categorically insufficient to establish dangerousness, and improperly increasing the state burden at a detention hearing by effectively requiring the state to conclusively negate the defendant's anticipated self-defense claim before detention. Okay, so it looks like they're only saying two things on this one. So they're pushing back saying basically what we just said, that they're saying that the appellate is saying that this was just a personal dispute. And two, they're saying that the appellate is saying because they could not disapprove self-defense at the detention hearing, then she does not present a danger, or that the state did not prove their case that she is a danger, okay? So statements of facts, let's go into it. On September the 8th of 2025, in the South Loop neighborhood of Chicago, on a busy street near an elementary school, defendants fatally shot the unarmed victim, Romika. Defendant was arrested on December 3rd and charged with 6 counts of first-degree murder. The state proffer at the defendant's detention hearing established that the defendant and Romika shared a personal relationship with Carlos Smith, who had fathered children with both women. On the morning of the shooting, Smith had driven defendant and their 6-month-old child from his home to the defendant's car, which was parked nearby. Romika, who had just dropped off her child at school across the street, drove past, made a U-turn, and double parked behind the defendant's car, boxing in defendant's car between her car and Smith's car. Now, I don't know what they take boxing in mean, but boxing in to me means blocked, okay? But anyway, an argument between the defendant and Romika ensued. A witness called the police and reported the argument. According to the accounts from the witness proffered by the state, Carlos repeatedly hit Romika with her own car door and then placed her in a chokehold. While Romika was being held in a chokehold, the defendant threatened to shoot Romika, then retrieved a firearm from her vehicle. When the unarmed Romika broke free and stepped backwards, oh, that's so funny to me, backwards. First, it was sideways. She stepped to the side. Now she's sliding backwards. I mean, goddamn, next they're going to have, she turned around and ran. Anyway, when the unarmed black man broke free and stepped backwards, Holly shot her multiple times. According to one witness, defendant and Smith exchanged a celebratory fist bump after defendant shot Romika. Defense counsel countered that Romika was the aggressor and that the defendant had acted in self-defense. Defense counsel presented evidence that the defendant had previously obtained a stalk and no contact order against Romika, which was entered on July the 14th of 2025. After Romika had sent the defendant and her family threatening messages, including a threat to kill Holly, counsel argued that some witnesses reported that Romika charged at the defendant's car with the infant inside immediately before the shooting, and that Smith, which is Carlos' car, had been blocking the defendant from driving away until moments before the shooting. Defense counsel also noted that Holly remained at the scene and cooperated with the police and that she had no violent criminal history, and that she held a valid FOID card and concealed carrier license, and that she ran her own business and volunteered in the community, and that she was pregnant at the time of the detention hearing. Defendant was not arrested until nearly 3 months after the shooting, 87 days to be exact. Following the hearing, the circuit court granted the state petition for pretrial detention. The court found that the state proffer established by clear and convincing evidence that Holly posed a real and present threat to the community, and that no conditions of release could mitigate that threat. The court emphasized that the shooting occurred in broad daylight near a school, that all witnesses except for Carlos, whom the court did not credit as independent, reported that Romika was never seen striking Holly and was unarmed. The circuit court denied Holly's ensuing motion for relief and defendant appeal. In a split decision, meaning 2-1, the appellate court reversed. Okay, the majority characterized the murder as arising from a very personal and specific controversy. And it absolutely was. I don't even know how they can sit here and say that it wasn't. Insufficient to establish that the defendant posed a danger to the community. So they're saying, even if it was just personal, that is insufficient to establish that she posed a danger to the community. All right. Found the defendant's lack of criminal history. Okay. Significant. Noted its view that conditions including a firearm prohibition could adequately address any risk, and observed that the defendant had remained at large for nearly 3 months without incident before she was arrested in this offense. Okay, so Justin Mitchell, which was the descendant, that was the judge that went against the 2 judges, okay? It says, Judge Mitchell, descendant on the grounds that the majority misapplied the clear and convincing evidence standard, disregarded controlling evidence of dangerousness, and created an unworkable rule that a single victim personal dispute killing can never support a finding that a defendant posed a significant threat to the community. So basically what they're trying to say is that 3rd judge that did not agree with the other 2 judge argued that y'all are saying a personal dispute, a one-on-one personal dispute, means that it can never arise to a person being a threat to the community, okay? Pose a significant threat to the community. So we can't put that out there is basically what they're saying. You can't just say, just because it was a one-on-one incident, personal, that does not rise to a threat to the community. All right, now, argument. The appellate court improperly narrowed the dangerousness inquiry by treating a personal dispute, killing, and lack of criminal history as effectively dispositive, I think that's how you say it, dispositive against the detention, or disposition, no, that's positive, against detention. Now, that is not what the appellate, and I know Ari is going to come back hard in the paint, because they didn't just say just because it was a personal dispute and just because it was a lack of history, a criminal history, that is the reason why they disproved their that she posed a danger to the community. That is not just what they said. They said a lot more than that. However, the state pulled that out and they highlighted those 2 things. They're saying that the appellate court weighed heavily on this was a personal dispute, and they weighed heavily on her lack of criminal history in making their decision. And in my opinion, I don't think that that was the case. In my opinion, the things that the state brought out did not prove that she was did not prove beyond, with a clear and convincing evidence, that she posed a threat. Now, what I probably would have highlighted more if I was the state, okay, that being out for 87 days does not prove that she won't do anything on the 88th day or the 89th day or the 90th day, okay? I probably would have went in that direction versus the personal dispute, but that's just me. I'm not a lawyer. Anyway, all persons charged with an offense are eligible for pretrial release, And that's per 725 ILCS 5110. However, a defendant may be denied pretrial relief if the defendant is charged with a detainable, eligible offense, and the state, upon verified petition requesting denial of the pretrial release, proves by clear and convincing evidence that the proof is evidence or the presumption is great that the defendant has committed a qualifying offense, okay? Now, they did prove that she committed a qualifying offense as far as they proved that unaliving was committed. The defendant pretrial and a qualifying offense, first degree, is a qualifying offense. So let me just say that, right? The defendant pretrial release posed a real and present threat to the safety of any persons or persons of the community, or a high likelihood of willful flight to avoid prosecution, and that no conditions or combination of conditions can mitigate the real and present threat to the safety of the person or the community to prevent the defendant willingness flight from prosecution. Okay. Now, I still do not believe that the state proved that. And mainly because she said, "Can you see me?" Yes, I can see you, exclusive. Mainly because, one, she was out for 87 days. Two, that this was a personal one-on-one issue. Three, she was not the aggressor. She didn't pull up on Ramika. Ramika pulled up on her. But four, all the things that the appellate list, I agree with them. I agree that the state did not prove clear and convincing evidence that no combination of conditions can mitigate that. No, you mean none? And the reason why I say that, because there are people that commit first degree or is charged with first degree and that are out fighting their case before they have to go to trial. Okay, because if that's the case, then they need to say that everybody that is charged with first degree, that should just be taken off the board, clear off the board. If you're charged with first degree, you're staying. So that basically they need to either say that or don't, right? Say that or prove that that no conditions or combinations can mitigate that risk, right? And I do not believe that the state proved their case. Let's continue. The court has defined clear and convincing evidence as the quantum of proof that leaves no reasonable doubt in the minds of the fact finder as to the truth of the proposition in question. It is intermediate standards that this is more demanding than a preponderance, but less demanding than beyond a reasonable doubt. Okay, so let me find out what this part right here means. Hold on. Let me just find out what this part means. Oh, shit, I can't do it like that. Okay, hold on. All right, give me a second. In my opinion, while this is coming up, I think that the state doesn't like that they lost at the appeal level, the appellate court level, and they're doing whatever they can to push back to try to take a win back. All right, so let's find out what this part means. Hold on. All right, hold on. I just asked for a smooth read, so we won't have to get all that jibber jabberish. All right, here we go.
Yes. Here is a smooth read using the exact verbiage with a little setup so your audience understands it. In this section, the state is explaining what the legal standard is for a pretrial detention hearing. They are saying the state does have a burden, but that burden is not the same as the burden at trial. The document says, open quote, "This court has defined clear and convincing evidence as the quantum of proof that leaves no reasonable doubt in the mind of the fact finder as to the truth of the proposition in question." It also says, it is an intermediate standard that is more demanding than a preponderance, but less demanding than beyond a reasonable doubt. Down. Close quote. Clear and convincing evidence is a middle standard. It is higher than just saying, this is probably true. But it is still lower than what the state has to prove at an actual criminal trial. At trial, the state has to prove guilt beyond a reasonable doubt. But at this detention hearing, the state is saying they only had to meet the clear and convincing evidence standard. That means the judge does not have to decide guilt or innocence right now. The judge does not have to decide whether self-defense wins or loses right now. The judge is only deciding whether the state has shown enough to justify keeping the defendant detained before trial. So the state's position is basically this, open quote, we did not have to prove the entire murder case at this stage. We did not have to disprove self-defense beyond a reasonable doubt at this stage. We only had to show clear and convincing evidence that detention was appropriate under the Pretrial Fairness Act. Close quote. And that is why this paragraph matters. The state is using it to argue that the appellate court treated the detention hearing too much like a full trial instead of a limited pretrial hearing.
Okay. All right. I understand. So basically, again, they're really trying to say the state the appellate court is jumping ahead. Which this leads me to believe like, anyway, I'm thinking that the appellate court is looking in the future like, like I said before, there's reasonable doubt, there's reasonable doubt, there's reasonable doubt. But anyway, I'm going to keep on saying it. So again, the state is trying to say the appellate court is reaching. The appellate court is going too far beyond. Right now, we are just at detention hearing, and they're treating this like a trial. They're basically saying there is reasonable doubt, right? They're leading off with reasonable doubt, but right now we are not fighting reasonable doubt. We are fighting clear and convincing evidence, all right? Now, in considering whether a defendant poses a real and present threat to the safety of any person or the community, i.e. making a dangerousness determination, the circuit court may consider evidence including, but not limited to, the nature of circumstances of any offense charged, including whether the offense was a crime of violence involving a weapon or was a sex offense. The history of characteristics of the defendant, including the defendant's prior criminal histories indicative of violence, abusiveness, or assaultive behavior, and a defendant's psychological history. The identity of any persons to whom the defendant is believed to pose a threat of the nature of the threat. Any statements made by or attributed to the defendants together with the circumstances surrounding the statement, and the age of the physical conditions of the defendant. Anyway, let me get all of this right here. Oh, okay, they're saying in considering whether she is a real threat, they have to consider all of this, right? I think that in my opinion, they're just basing it off of the charge. They're saying she's a threat because of the charge, first-degree murder, because nothing else lines up to me. But we're going to find out what all of this means. Give me a second. All right, here we go. This explains this part right here where they're saying, in considering whether Holly poses a real and present threat to the safety of any person or the community, okay? This is what they're saying that the judge is allowed to look at.
Yes, here is a smooth read for that section, keeping the legal meaning and using the important exact verbiage from the document. Now, the state is explaining what a judge is allowed to look at when deciding whether a defendant is a danger under the Pretrial Fairness Act. The document says, open quote, in considering whether a defendant poses a real and present threat to the safety of any person or the community, the circuit court may consider several factors, dangerousness determination.
Oh, man.
Close quote.
All right, it's skipping. All right, so let me read that part. So, this is about the dangerousness determination. The court is not limited to one thing. The judge can look at the whole picture, and that includes the nature and circumstances of the offense, including whether it was a violent crime, whether a weapon was involved, and what actually happened during the incident. The judge can also look at Holly's history and her characteristics, including any prior criminal history that shows violence, abusiveness, or assaultive behavior, or the lack of that kind of history. The courts can consider who Holly is believed to be a threat to. What kind of threat is being alleged? Any statements made by Holly, the age of Holly, the physical conditions of both the defendant and the victim, whether Holly has access to any weapons, and whether Holly was already on probation, parole, or some other form of supervised release when the offense happened. The document says something very important. No one factor is determinative, and that the court must base its decision on an individualized assessment. This means no single fact automatically controls the outcome. So the state is saying that the appellate court should not have just focused heavily on things like whether it was a personal dispute or if Holly has a violent history. Those are factors, but they are not supposed to be the only factors. The state argument is basically saying you have to look at everything, not just one or maybe even two. You have to look at the shooting, the location, the weather, whether it was weapons, the alleged conduct, the people nearby. What did the witnesses say? The victim, her family, the defendant's history, and whether any conditions could actually manage the risk. You cannot take one or two favorable facts and let those override the entire dangerousness analysis. So it's saying the law does not say the judge only looks at criminal history. It does not say that the judge not only look at whether the victim and the defendant knew each other. The law says the judge looks at the totality of the circumstances. And the state is arguing that the appellate court failed to do that by giving too much weight to the personal dispute angle and the lack of prior violence history. So the state is basically saying or accusing the appellate court of just chiming in, zoning in to just two factors: her lack of prior violent history, and that this was just a personal issue. But we all know that that is not what the matter of fact. We're going to finish reading it, but let me bring in the appellate court's ruling right quick. Give me a second, because that's not what the appellate court was only focusing on, you guys. And I actually think that Ari is going to push back hard on this fact. Give me a second. I'm going to bring the appellate court ruling in here, and I'm going to ask ChatGPT to tell me did the appellate court rely heavily on just those two things? Because I don't think so. I know I read off a lot of things. I know it's been a minute since we went over this, but I know that there was a lot of things, several things that the appellate court made issues with. Okay. Give me a second. I think this was it. I don't think that they put it in here, did they? Give me a second. Oh, wow. Give me a second, y'all. I'm sorry. I'm trying to just get what the appellate court wrote. I have so many files up here. I just wanted to do a quick analysis of hold on. Why is all right, this is not it. Is it? No, that's not it. That's the response of the state. And this is their corrected thing. Okay, so if that's it, then that must be afterwards. Okay, but it got to be on the next page. Give me a second, y'all. I'm looking for the So did they take it out? I think they took it out, y'all. They must have hid it. They must have hid it. Anyway, let me take this. Let me put this one in here. Give me a second, y'all. Give me 1 second. All right, I'm sorry. Give me 1 second. For some reason, I cannot find it. I know I have it. So I just asked somebody, can they send it to me? All right. Until they do, let's continue. I know I have it, you guys. I'm just trying to figure out. Matter of fact, hold on. Okay, bam. I didn't even know you could do this. Okay. So with that said, tell me if the state requests to the Supreme Court about the two things focusing on. Because the appellate court okay, so somehow ChatGPT stored it and then they just brung it up. So now I'm asking them, did the appellate court just weigh heavily on just two things, or did the appellate court have more than that? And it is the state basically pointing out those two things. Is it a weak? Okay, here we go. Let's listen to it, y'all. Sorry about that, you guys.
Yes, that is actually the weak spot in the strength of the state's petition at the same time. The state is focusing on two big legal issues because that is how you get the Supreme Court's attention. The Supreme Court usually does not take a case just because one side says the appellate court weighed the facts wrong. They are more likely to take it when the petition says the appellate court created a legal rule that will affect other cases statewide. So the state narrowed it down to: 1, did the appellate court improperly treat a personal dispute killing as less dangerous? 2, did the appellate court improperly require the state to basically disprove self-defense at the detention hearing? Teji. But you are also right. The appellate court did not rely on just one or two things. The appellate...
Okay, y'all know, I don't know what's up with ChatGPT today, but they skipping some shit. I want y'all to hear it all. All right, so basically it said, yes, this is actually the weak spot and the strength of the state's petition at the same time. Why do they call it the weak spot and the strength of the state's petition at the same time? The weak spot is they're saying that the appellate court basically held weight for just two different things, which is not true. But the strength of it is they're trying to get the Supreme Court attention. And in order to get the Supreme Court attention, it has to be something statewide, and it has to be a fault from the appellate court. So let me go on and say what they said. Yes, that is actually the weak spot and the strength of the state's petition at the same time. The state is focusing on two big legal issues because that is how you get the Supreme Court's attention. The Supreme Court will not take a case one side. Wait a minute. The Supreme Court usually do not take a case just because one side says the appellate court weighed the facts wrong. They are more likely to take it when the petition says the appellate court created a legal rule that will affect other cases statewide. So what the state did, they narrowed it down to just two things. Did the appellate court improperly treat a personal dispute in a personal dispute killing as less dangerous? Did the appellate court improperly require the state to basically disapprove self-defense at the detention hearing? Now, ChatGPT said this was actually a smart strategy from the state's side, all right? But it also said you are also correct that the appellate court did not rely on just two things. And this is what Ari comes in at, and she's going to have to push back because the state actually did not tell the truth. They wasn't honest about they weighed heavily on two things. Okay, so Ari will have to come in and disapprove that, right? So it said you are also right. The appellate court did not rely on just one or two things. The appellate court majority brought up several facts in Johnson's favor. They pointed to her lack of violent history, the protective order that she had against Romika, the fact that Romika allegedly initiated this shit by approaching Holly and not the other way around, The fact that Holly stayed at the scene and cooperated with the police when she could have fled. The fact that Holly did have a FOID card and a CCL license, okay, that she was in compliance, that Holly was preggo at the time of the incident, and that Holly had already been free for 87 days without any arrest, without any incident. So she was out already for almost 3 months and nothing happened. So again, the appellate court did not just weigh on her violent history, whether this was a personal attack or whether or not the state had to disprove self-defense. They just put that in there. But Ari is going to have to come back and say, no. They left out a lot of other things that the appellate court brought up, okay, in Holly's defense. Now, that gives the defense a strong response. Is the state argument strong? Yes, but with a catch. The state argument is strong as a Supreme Court reviews arguments because they are saying this is not just about whether the appellate court liked certain facts. They are saying the appellate court reasoning could create a broader rule that hurts detention cases statewide. The state is basically saying the appellate court gave too much weight to the facts that this was just a personal dispute and to the facts that Holly has no violent criminal history. The law says not one factor is determinative, and courts must look at a whole picture. That's strong legal argument because the state does not say courts may consider many factors, and not one factor is supposed to control the outcome. The state also has a strong argument on self-defense because detention hearings are not supposed to be the full trial. The state is saying that the appellate court treated the self-defense claim like it had been defeated now, okay, instead of leaving that for the trial to come. But here is where the state will have a problem, all right? I need y'all to get your glasses and wine or whatever and listen up, okay? This is where the state will have a problem. The appellate court did not literally say because this was personal dispute, she must be released. And the appellate court did not literally say because she has no violent history, that she must be released. The appellate court said it looked at the overall facts and believed conditions could manage the risk that matters. So the defense can come back and argue the state is exaggerating what the appellate court said. Okay, the appellate court did not create a new rule statewide. It made an individualized assessment based on all the facts presented to them. That is probably the defense's best response. So who has the strongest position for Supreme Court review? For getting the Supreme Court to accept the case, the state has a solid argument because they framed it as a statewide Pretrial Fairness Act issue. However, for winning on the narrative is more complicated. The states will say the appellate court minimized a public shooting near a school because it came from a personal dispute. The defense will say, no, the appellate court considered the totality of circumstances, including the protection order, including the prior threats from Romika, including that Holly had no violent history, including that Holly was a lawful firearm carrier, including that Holly cooperated with law enforcement, including that she was pregnant at the time of the offense, and including that Holly stayed violent-free for 3 months from the incident, from the day of the incidents prior to her arrest on December the 3rd. So both sides do have something to work with. However, the state's petition is strong when it says the appellate court may have gone too far by making this look like a personal conflict. No criminal history equals release. But the defendant's strongest comeback is that the appellate court did not base this ruling on only two things. It listed multiple reasons why it believed Holly could be released with some conditions. So yes, the state argument is strong enough to possibly get the Supreme Court's attention, but the defense has a very reasonable argument that the state is oversimplifying the appellate court's ruling, which means the state is reaching, okay? So the state is trying to turn this into a statewide issue. And it's smart that they do that because that's the only way the Supreme Court will even get involved. They are focusing on two big questions: personal disputes, killing, and self-defense at detention hearing. But the defense is going to say, hold on, wait a minute. That's not what happened. The appellate court did not release Holly because it was just based on a personal dispute or whether or not she had a violent history. The appellate court looked at multiple things and they made an individualized assessment due to the facts that were submitted to them from the state and from the defense. So the Supreme Court may have to decide whether or not the appellate court truly created a bad legal rule or whether it simply weighed on all the specific facts during the trial. All the specific facts differently than the trial judge did, okay? So with that being said, will it be accepted by the Supreme Court? ChatGPT thinks it will because they made it a statewide issue, okay? But will they win at the Supreme Court? Maybe a different story, okay? If Ari pushes the envelope and say the state is reaching, that is not what happened. The appellate court did not just narrow it down to two things. They have a great possibility of knocking that down. But however, the way the state framed it, will it get the attention of the Supreme Court? It most likely will. It most likely will. Let's continue, you guys. All right. So I think we're down here to the, let me make sure. Yeah, we're down here to the majority analysis in this case. So the majority analysis in this case focused on the facts that the crime was a cumulative of a very personal and specific controversy, and the relationship between just these two women. The majority personal dispute analysis suggests that if a crime involves parties known to each other, then the offender is less likely to pose danger to the community. However, the plain and ambiguous language of the PFA does not limit the dangerousness determination to offense against strangers. The PFA requires the court to assess the nature and the circumstances of any offense. The statutory language is broad. So basically, the state is still trying to say that the PFA does not say that if it is a personal, if it only limits, the offense only involved just one or two people, and if they knew each other or not, that the the state is trying to say that does not mean that Holly is not dangerous just because she knew the person and just because it was personal, okay? Now, let's go on. It says the statutory language is broad. The 725 ILCS, the nature of circumstances, and which is the pretrial, I think this is the Pretrial Fair Act. The nature of circumstances of any offense charged, including whether the offense is a crime of violence involving a weapon or a sex crime. People versus Parker. Should discussing facts court consider in making it dangerousness determination. This is amplified by People versus Carter. So basically, the state is giving different case laws as to why the court should consider more than just one thing to say whether or not Holly is a danger or not. And I think I went over all the things that they can consider to say whether or not she was a danger to, and that no circumstances whatsoever can get a risk of further crime happening, okay? So then it goes on and say, Okay, this one says whether the defendant claimed that the circuit court's finding that he presented a real and okay, yeah, that's of that case. Okay. So the defendant argued that the state's proffer was inadequate because it considered solely on the facts of the charge crime. In rejecting the defense argument, the appellate court stated that the defendant arguments find no support in the language of the code. All right, so this is all pertaining to People versus Carter. All right, now let's get down to the real nitty-gritty. Let's see if this is still talking about this case, People versus Carter. The court then explained to be sure that there are a great many pretrial detention cases in which other statutory factor. Okay, yeah. Wait a minute, hold on. Okay, let me put this in here because I think this is the state trying to say this is what the Supreme Court used to win this one. Hold on. I think that's all this is saying, y'all. Is this, oh, let me just say. Is the state all right, hold on. I think they are using this as this is what the state came back with this case law. Not the state, but the, yeah, I thought so. Okay. Yeah, so basically they're taking the language of a case that went before the, what did it go before? It went before, oh, the appellate court. Yeah, so this went before the appellate court. So they're saying that the appellate court is treating this case differently than they've treated other cases before, because the appellate court actually said something different when it came to the People versus Carter in 2024. Hold on. Okay, I see what they're doing. So basically it's saying, it says that the state is saying that in this case, the defendant argued that the state proffer was not enough. Let me just summarize. I don't want to have to read all of that. The state is using this case, People versus Carter, to argue that the appellate court put too much weight on Holly not having a violent record. The point is a clean record does not automatically defeat detention. The court can look at the actual facts of the charged offense, and if those facts are serious enough, the offense itself can support a dangerous finding. So the state is basically saying the fact that she's being charged with first degree, she did the shooting, and that there was no weapon on the victim, that right there should be strong enough to say that there was dangerous findings. Okay, it support dangerous findings. And then you put other stuff to it, like the weather across the street from the school, other kids around. They're trying to say that's what they came up with, that this was dangerous enough for her to stay locked up until trial. And these cases right here is saying they said that this person lack of criminal history wasn't enough to keep them not locked up. So this person right here didn't have a criminal history. So that's what they're doing. They're just breaking down different cases, trying to dispute what the appellate court actually said, her lack of criminal history, the fact that this was just a one-on-one or a personal dispute between just two people versus a broad thing. They're saying that these cases before, y'all did not rule on that. Okay. So anyway, and let me just go down. So what I'm going to do, you guys, because it looks like they're repeating themselves to me. They didn't bring out anything else except for just those two things. They literally narrowed it down to just those two things. And then all these are just case laws. They just put a whole lot of case laws on there. So I'm going to do me and you guys a favor. And I'm about to summarize the entire document for y'all, okay? And it's not going to be long, all right? It's going to be very short. When y'all like that, let's summarize this whole entire document because they're repeating themselves with a bunch of case laws. So we're going to summarize the entire document. Give me a second. I think it's this one. The meat and potatoes of the entire thing. That's what we're going to do. Give me a second. All right, here we go, you guys. Let's get ready. We're going to hear this entire thing. The summary, I'm summarizing the entire 37 page because it's redundant and it's a bunch of case laws, them trying to prove that the state cannot just narrow down on two things. Excuse me, the appellate court cannot narrow down on two things, which we know that that's not what the appellate court did, but that's what the state is trying to present. So here we go. Let's listen to the whole entire thing.
Here is a smooth read summary of the entire document. This document is the state of Illinois' petition for leave to appeal to the Illinois Supreme Court in the case of People v. Quadaja Johnson. The state is asking the Supreme Court to review and overturn the appellate court's decision that reversed Quadaja Johnson's pretrial detention and ordered the trial court to consider conditions for her release. This case is important because, in their view, the appellate court created two dangerous legal problems under the Pretrial Fairness Act. First, the state says the appellate court wrongly treated this killing as if it was not enough to show dangerousness simply because it came out of a personal dispute between two women connected to the same man. The state's position is that just because a violent crime grows out of a personal conflict does not mean the person accused is not a danger to the community. They argue that the law allows courts to consider the nature and circumstances of the offense, including whether it was violent, whether a weapon was used, where it happened, and how it happened. According to the state, a person allegedly shooting someone multiple times in broad daylight near a school on a public street can itself support a finding of dangerousness. Second, the state says the appellate court improperly raised the state's burden by treating Quadaja's possible self-defense claim like something the state had to completely disprove at the detention hearing. The state argues that a detention hearing is not a trial. At trial, if self-defense is raised, the state has to disprove it beyond a reasonable doubt. But at a pretrial detention hearing, the state only has to prove the detention factors by clear and convincing evidence. So, in the state's view, the appellate court made the detention hearing look too much like a full trial by requiring the state to practically defeat self-defense before trial even begins. The background of the case is that Quadaja Johnson is charged with first-degree murder for the September 8, 2025 shooting death of Romika Blackman in Chicago's South Loop. The state says Blackman had just dropped off her child at school when she encountered Johnson. Both women had children with the same man, Carlos Smith. According to the state's proffer, Blackman double parked behind Johnson's car. An argument started. Smith allegedly hit Blackman with her own car door and placed her in a chokehold. And then Johnson allegedly retrieved a gun and shot Blackman multiple times after Blackman broke free and stepped backward. The state also referenced a witness claim that Johnson and Smith exchanged a celebratory fist bump after the shooting. The defense argued a very different version. Johnson's side says Blackmon was the aggressor, that Johnson had already sought and obtained a stalking no-contact order against Blackmon, and that Blackmon had previously sent threatening messages, including threats to kill Johnson. The defense also argued that Blackmon boxed Johnson's car in, rushed toward Johnson's car, where her infant was inside, and that Johnson acted in self-defense. The defense emphasized that Johnson stayed at the scene, cooperated with police, had no violent criminal history, had a valid FOI card and concealed carry license, owned a business, volunteered in the community, was pregnant, and was not arrested until almost 3 months after the shooting. The trial court originally sided with the state and ordered Johnson detained. The trial judge focused heavily on the fact that the shooting happened in broad daylight near a school, that Blackmon was unarmed, and that the witnesses, other than Carlos Smith, did not report seeing Blackmon strike Johnson. The judge found that Johnson posed a real and present threat to the community, and that no conditions of release could reduce that threat. But the appellate court reversed in a split decision. The majority found that the state had not proven Johnson was such an ongoing danger that she had to remain jailed before trial. The majority emphasized that this was a personal and specific conflict, that Johnson did not seek out the confrontation, that she had tried to use the legal system by getting a protective order, that she stayed and cooperated with police, that she had no meaningful violent criminal history, and that she had been free for nearly 3 months before arrest without any new incident. The majority also believed conditions could reduce any risk, especially a ban on firearm possession. The appellate court also pointed out that Johnson was pregnant and noted Illinois policy against forcing a pretrial detainee to give birth in custody unless continued detention is necessary to protect someone or the community. The majority said Johnson should be released sooner rather than later, so she could prepare for birth and prepare for trial with her attorney. Presiding Justice Mitchell dissented strongly. He argued that calling this a personal dispute misses the bigger danger. In his view, if someone allegedly resolves a public argument by pulling a gun and killing an unarmed person near a school, that shows a serious risk to public safety. He said the issue is not just whether the victim is now deceased. The issue is whether Johnson showed she may respond to future conflict with lethal force. He also rejected the idea that no prior violent history should carry so much weight, saying the law does not give first-time offenders a get-out-of-jail-free card when they are accused of serious violent crimes. He believed the original detention order should have been affirmed. The state is now using Justice Mitchell's dissent as support for its petition. The state argues that the appellate majority created a bad rule by suggesting that a murder tied to a personal dispute is less likely to show community danger. The state says that is not what the Pretrial Fairness Act says. According to the state, the law requires an individualized assessment, not a shortcut that says personal dispute plus no criminal history equals release. The state also argues that the appellate decision could affect detention hearings across Illinois. Their concern is that if this ruling stands, defendants in serious violent cases may be released simply because the violence involves someone they knew or because they raise a possible self-defense argument early in the case. The state wants the Illinois Supreme Court to clarify that courts may rely on the violent facts of the offense itself, and that the state does not have to conclusively disprove self-defense at a detention hearing. In plain terms, the state is asking the Supreme Court to answer 2 big questions. 1, can the violent nature of a crime support a dangerousness finding even when the crime came from a personal dispute? 2, does the state have to fully disprove self-defense at a detention hearing before a judge can order someone held before trial? The state's bottom line is that the appellate court, in their opinion, made the Pretrial Fairness Act too narrow, made the state's burden too high, and created confusion for future cases. They want the Supreme Court to step in, take the appeal, and restore the trial court's ability to detain defendants when the facts of the alleged offense show a real and present threat to the community.
Okay, so then I did a step further and I said, okay, understood. Now can you point out the state's strong points and their weak points and how the defense could possibly defeat this at the Supreme Court level? Listen up.
Yes, the state has some strong legal framing, but the defense also has several strong ways to fight this petition, especially because the appellate majority already gave them a roadmap. Here's the clean breakdown. The state's strongest points. The state's strongest point is that this was not a minor offense or a technical violation. They are arguing from the seriousness of the alleged facts: a public shooting, multiple shots, an unarmed victim, broad daylight, near a school with children and bystanders around. That gives the state a powerful public safety argument. Their position is basically, even if this started as a personal dispute, the way it ended shows danger to the community. The state says the Pretrial Fairness Act allows courts to consider the nature and circumstances of the charged offense, including violence, weapons, and the surrounding facts. Point is that they are not asking the Supreme Court to decide guilt. They are asking the court to clarify how detention hearings should work. That matters because the Supreme Court may be more willing to take the case if the state can frame it as a statewide legal issue, not just a disagreement over one defendant. The state says the appellate court's decision could affect detention hearings across Illinois by making judges less able to detain someone when a violent crime came from a personal dispute. Their third strong suit. The state argues the appellate court treated Quadaja's self-defense theory like something the state had to fully disprove right now. The state's argument is that a detention hearing is not a trial. Discovery may not be complete. Witnesses may not have testified live, and the state should not have to defeat self-defense beyond a reasonable doubt at this early stage. That is probably one of their cleaner legal arguments because they can say self-defense matters at trial, but detention is a separate preliminary question. Their fourth strong point is Justice Meeson gave the state strong language to use. He basically said the majority made a dangerous mistake by treating the killing of a romantic rival as too personal to matter for public safety. He emphasized that the alleged act showed a willingness to use lethal force during conflict and that future conflict can happen again. The state's weaker points. The state's biggest weakness is Jordy did not say murder can never justify detention. The majority said this specific record did not prove Quadaja remained an ongoing threat that no conditions could address. That distinction matters. The defense can argue the state is exaggerating the appellate ruling and acting like the majority created a blanket rule when it really performed a fact-specific review. Another weakness is the 3-month delay. Quadaja was not arrested until almost shooting, and the appellate court found that important. The defense can say, if she was truly such an immediate danger.
Okay, it started skipping. All right, let me go back up. So we heard the strong points, right? They pointed out 1, 2, 3, 4. 4 strong points for the state, okay? The 4 strong points, and I'm not going to go over the whole thing, but the strongest is that this was not a minor offense or a technical violation. So first-degree murder is not a minor offense. That's something very, very serious. First degree, I want to say, I don't know if they have capital murder, but first degree may be one of the strongest in the state of Illinois, okay? So this wasn't just something minor, okay? Now, that's their strongest point. Let me get back to it. That's their, that's number 1. Their strongest point is that this was nothing minor. Number 2 is that they're asking the Supreme Court to decide guilt. Or they're not asking the Supreme Court to decide guilt. So they're not saying make a ruling on this case. They're just saying that this is something that could affect they're just saying something. They're asking the courts to clarify how detention hearings should work at the detention level, okay? And statewide. They're making it into a statewide issue. Third strongest point is the burden issue. The state argues that the appellate court treated Holly's self-defense case like something that they should solved at the detention hearing and not the trial hearing. The fourth one is that they're saying the descendant, which is Justin Mitchell, the third judge, did not agree with the other two judges. So there was conflict there. So there's 4 strong points that the state has. Now, their weaker points are this. The state's biggest weakness is that the appellate majority did not say murder can never justify detention. The majority said this specific record did not prove that Holly remained an ongoing threat and that no conditions could address it. Okay, that distinction matters because the defense can argue that the state is exaggerating the appellate's ruling, and they are, and acting like the majority created a blanket rule when it really just performed a fact-specific review. Another weakness of the state is that the 3-month delay. Holly was not arrested for almost 3 months, you guys. She was out after the shooting 87 days. And the appellate court found that important. The defense can say if she was such an immediate danger to the community, then why was she out for nearly 3 months with no incident? That undercuts the state's real and present danger and real and present threat argument. The state also has a weakness on condition of release because the appellate majority pointed out that Khadijah had a FOID card and a concealed carry license, meaning that she had previously followed legal process for firearm possessions. So the majority used that to reasons that she may also follow a court banning firearms. So if they come back and say you can't have a weapon, then she won't have a weapon. So the defense can argue that conditions like no weapons, GPS, electronic monitoring, or no contact with witnesses, home confinement, and surrendering of firearms could address the risk. Another weak spot is the self-defense record. The defense has several facts that complicates the state's version. Holly has sought a stalking no contact order against Romika. Romika allegedly threatened her before. Romika allegedly boxed in her vehicle. There was a 911 caller who reportedly described Romika as the aggressor. And the defense counsel argued Romika rushed toward Holly while she had her infant inside of her car. That does not automatically prove self-defense. However, it makes the state's case less clear at the detention stage. The pregnancy issue is also a defense-friendly fact. The appellate court noticed Illinois policies that a pretrial detainee should not be required to be in custody unless continued detention is necessary for safety purposes. That gives the defense an equality statutory policy argument. Even if the charge is serious, the court must still ask whether detention is truly necessary right now. Okay, so how the defense could possibly defeat the state's petition, and this is if the Supreme Court picks it up. The defense best strategy is to say the state is trying to turn a fact-specific appellate decision into a fake statewide crisis. This is not a statewide crisis. The appellate court did not create a rule that personal dispute murders can never show dangerousness. Instead, what the appellate court did, they looked at the whole record of Holly. They did not seek out, they looked at the whole record, that Holly did not seek out the confrontation, Romika did. That she had tried to previously get legal protection against Romika. Okay, she stayed at the scene and did not flee. She cooperated with the police and she had no violent history. She was out for nearly 3 months with no incident, and conditions could reduce any risk. That is not a categorically rule across the state. This is an individualized assessment only. This is just about Holly Johnson only. This is not an Illinois statewide issue. Defense could also come back and argue that the state miscategorized the self-defense issue. The defense does not have to say the appellate court required the state to fully disapprove self-defense. They can say the appellate court simply considered the competing facts because those facts matter to whether Holly is an ongoing danger to the community. In other words, the defense can frame it like the appellate court did not decide self-defense. It recognized that the state's version was contested and that the contested facts weakened the arguments for no release detention. See, the state brought it as if this was an intentional, malicious murder that Holly committed. That is the state's version, that she sought out to murder, unalive Romika. And the defense came back and said, no, that is not the case. This was merely self-defense. And the appellate court said, well, hold on. We're not deciding if it's self-defense or not. However, because of the self-defense argument, she should not have to stay locked up because there could potentially be a self-defense case. Another defense argument is that the detention under the Pretrial Fair Act is not a punishment. This rule was not put in place to punish a defendant. The state may keep focusing on the serious nature of the crime. Yes, first degree murder is a serious offense, but the defense can say seriousness alone is not enough. It's just absolutely not enough. Many people have been charged with serious offenses and was found not guilty. So the question is not, was the alleged act horrible? The question is, does this person, Holly Johnson, currently pose a real and present threat, and that no conditions, not one of them, can be mitigated? The appellate majority answered no based on this record. The defense can also lean heavily into alternatives to detention. They can say Holly can be ordered to surrender all of her firearms and not apply for any new weapons. Holly can have no contact with the witnesses. Holly can be mandated to stay away from even Carlos if needed. Remain on an electronic GPS monitoring. Follow home confinement. Attend all her court dates and obey by any travel restrictions. So the defense can say, listen, there's a lot of things that could be put in place and still Holly could be released. So if the court believed that those conditions can reduce the risk to public safety, then detention is not legally necessary. So the state's position, no, it's not weak, all right? They did what they had to do to get the Supreme Court attention, but it is not a guaranteed winner either, all right? Their strongest chance is getting the Supreme Court interest in the legal questions, whether the appellate court gave too much weight to personal dispute and whether it made the state burden too high on self-defense. But Ari has a very real path to defeat the state by saying the state is overreaching. They're overstating what the appellate court even said. This is not what the appellate court said. The defense can argue that this was not a broad legal rewrite of the Pretrial Fair Act. It was a narrow decision based on unusual facts, prior threats, protective order history, cooperating with the police, no violent history, delayed arrest, pregnancy, and possible release conditions, okay? So the state best argument is a public shooting near a school with an unarmed victim is enough to show dangerousness, even if it came from a personal dispute or not. The defense best respond is, hold up. The law does not allow detention just because the charge is serious. The states still have to prove an ongoing, real, and present threat that conditions could not be managed. And the appellate court found that they did not reach their burden. And now they are reaching to the Supreme Court. So that is the gist of this document, you guys. That is the gist of this document. Again, Ari has up to 21 days. Now, her 21 days doesn't start like right now. It actually starts at the time that this was due to be turned in, which I do believe that they had a few more days. So, but it doesn't matter. She has up to 21 days. However, we already know the defense is ready. The defense is going to submit this way before the 21 days. Okay. So we already know that's going to happen. So once she submit this up to the Supreme Court, I will bring what she wrote, I'm sure it's going to come strong. And she's going to basically point out that, that the state is actually not even saying everything that the appellate court considered. Okay. Again, it's not a weak petition from the state because they did bring in something that could possibly get the Supreme Court's attention. In my opinion, do I think it's going to work? No, but that's just my opinion. I don't think it's going to work because I see that the appellate court, they didn't just focus on two things. They focused on the overall picture. However, the fact that they did bring in statewide decision, it may make the Supreme Court accept it and take a look at it. Okay. But do I think that it will win? No, I do not. I have to see what Ari is going to come back with. If Ari's response is strong, then I think that Holly will be coming home soon. It's all based on the defense response at this point. Okay. She says she was out when W3 was lying, witness 3 was lying on all these podcasters and she didn't do anything to her. And that is the state's star witness so the state can stop that bullshit. You're exactly right. You're exactly right. She didn't reach out to that girl and try to find out who she was or any of that, because she wants her day in court. Okay. She says, out of all the cases for the state's attorney takes to the Supreme Court, they choose this case. Ari needs to sue the hell out of the state next. I don't know if that's going to happen or not. The state released her September the 9th. If she was such a threat, why didn't they charge her immediately? That's the same thing that Ari will be arguing. And that is one of the things that the appellate court pointed out. So I was actually surprised that the state did not even mention that at all. She was out for 87 days. If she was such a threat, then why didn't any incident take place between those 87 days? Okay, that further proves that she's not a threat. This was an isolated issue. This was an isolated incident. Okay, but the state now trying to come back and say, even if it was an isolated incident, she was charged with a serious offense, and a serious offense should be taken seriously. Okay. She said, maybe I'm overly optimistic, but I don't think the state have a strong case. I wouldn't say it's strong. The only reason why I said it's not a weak case is because when you do include statewide issues, it does get the Supreme Court's attention. Okay. And to be honest with you, we don't want it to even get the Supreme Court attention because the Supreme Court may take 3 to 4 months to decide. And Holly has to sit for an additional 3 to 4 months. So we don't even want it to get the attention of the Supreme Court. But I do believe that this will get the attention of the Supreme Court. But that doesn't mean that they will win. But we don't even want Holly to have to sit for another 3 to 4 months because of why? Because why? Why should she have to sit for additional 3 to 4 months when, in my opinion, it was a clear self-defense case? Okay. She says, and Ari hasn't disappointed, so she ready. Exactly. Ari has not disappointed at all. So yes, I do believe she's going to come back strong because hell, I'm not even a lawyer and I would. Ramika bought the confrontation by the school. Yes, she did. She did. It would not have been by the school. It would not have been around children. It would not have been in broad daylight had she not pulled up in broad daylight by the school where there are kids. She created the environment. She created that environment. Okay. She did. When is she due? Oh, I'm not sure, baby. I'm not sure. I knew they were going to pull this BS. Innocent people in Chicago have to fight while criminals walk. This happens all the time. Yeah, I do believe that Holly is innocent. As far as when I say innocent, I do believe that this would not have happened yet for Romika. Okay. So somebody sent this to me, and I did not know that, and I don't know. Y'all know I don't like La Leslie at all. I don't give a fuck if she's supposed to be a part of the family or not. I just do not like that lady. I think she's a fucking troublemaker. However, somebody sent me what she said. Oh, y'all say Goldman. Okay, let's celebrate in 1 second, you guys. In 1 second. Let me just show this right quick. Because La Leslie, in my opinion, is a troublemaker. And I don't give a fuck what anybody has to say about it. This is my channel. If you don't like it, you could get the fuck on in that order. She says, breaking news, state files PLA in Supreme Court on May 18, 2026 in Quadasia Johnson case. States put in motion that Romika was shot several times by Quadasia Johnson. This is the reason the state took this case to the Supreme Court. This psycho shot Romika 7 times. Ain't no self-defense. This was an execution, period. Justin for Romika. Holly did not shoot 7 times. People just spread rumors. They get people excited. They put shit out there like this. And they want the bloggers to run with it, okay? Now, there will be a blogger that run with it. Some bloggers will push back and they will say, this is incorrect information and I'm not going to spread this incorrect information. But I guarantee you, there will be 1 or 2 bloggers because they don't know shit about the case. They don't do no research whatsoever. They just believe any and everything that they see. They will take this and they will run with it. And they will say that Holly was a psycho and shot Romika 7 times. Now, if you listen to the sound of my voice, I'm going to assume that you are a supporter of mine, even if you might not be. This statement is untrue by La Leslie. She's not being truthful, and she has not been truthful with a lot of the things that have came out of her lying ass, troublemaking ass mouth. I don't like her. She don't like me. I don't give a fuck who she is. I don't owe her no loyalty. Only those content creators that lick her ass owes her loyalty. She could kick rocks for all I care, okay? She jumps on different panels because she's a fucking shit starter, lying ass individual, all right? And in my opinion, I believe she's doing a lot of this. Anyway, it doesn't matter. I don't like La Leslie and I don't respect her over here on this channel. So if you respect her, if you want to kiss her ass, I'm going to need you to go to somebody else's channel and suck out her ass because we ain't sucking out her ass over here. She's a liar. Holly did not even fire her weapon 7 times. All right. So thanks for sending me that from that damn liar. She says she is a troublemaker, and I'm glad you said it. Oh, yeah, I'm not holding no punches over here. I don't give a fuck, and I don't care what any of those other people have to say about it. That auntie constantly lying because she knows the truth isn't in Romika's favor. Exactly. She knows that Romika was not this idle princess that they are trying to present her to be. And when I say, if you are new to my channel, I don't know if anybody is new to my channel, but if you are new to my channel, people say the things that I say like that is me talking against the dead. If you think I'm talking against the dead, then you can jump on their hate bandwagon. But I'm not talking against the dead. I'm talking the truth, one, and I'm not holding no punches because she is no longer unalived, okay? I'm not doing that. I won't do that to nobody, okay? So they could tiptoe around it and, you know, all they want to. Is not going to be done over here on Talk About It with Amoira, all right? She said Keys already did. So Keys carried the 7 times. So Keys repeated what she said. God damn. Wow. She said, how did she go from 2 to 7? Well, because they want people emotionally wrapped up. So what they do, they lie. They lie to keep people emotionally wrapped up. She said, this is so sad to be bold-faced lying. That part. She said, Romika, people see nothing wrong on her actions. Yep. She says, I thought she corrected it and said she meant several times, not 7. Oh, I don't know. I just received this screenshot. So she shouldn't never put that shit out. 7, the number 7 is several. I can see if you misspell several, right? I can see if you put a SECERAL, but she put the number 7. That is not that's not a mistake, okay? What she meant several, not 7. That's a number versus a misspelled letter, okay? So even if she did correct it, she meant exactly what the fuck she wrote. 7 times is not several, okay? Because several, I can see you misspelling the word several, but misspelling several does not say 7, okay? Did they read the autopsy? Just stupid. Girl, she did correct it. Okay, so she corrected. Okay, so I was only sent just this. So if she corrected, that's good. She probably corrected because she knew I was coming and she knew I was going to call her ass out. All right. So with that said, she knew what the fuck she was doing in the beginning. Keys just posted his thumbnail. Now what he said, I didn't know. I don't watch him. Yeah, I don't watch him either. Okay, I don't watch him either. I used to in the beginning when I didn't know how to get the paperwork. But now that I know how to get the paperwork, fuck Keys. In my opinion, fuck him. And anybody that have a problem with me saying fuck him, fuck them. You know what I mean? But anyway, that's enough fucking going on. I do not want to go too far because I want to go on TikTok and I want to hold an open panel. And I want you guys to talk about this. You know, tell me how you feel. We could do it over here, but I need the TikTok hours anyway. So I'm going to drop my TikTok page. And if you would like to come over and jump on the panel and let me pull up my TikTok right quick. And we will have this discussion over there. Always telling me I got to log in. I don't know why it does this every time. Hold on, you guys. Let me drop my TikTok. I done got into the TikTok streets, y'all. Now, I still don't know my way around TikTok like that, but we learning it, baby. We learning it. Hold on. She said this case really brings the Chicago out of Amoira. You already know. Listen, I was born in Chicago. You hear me? I may not have been raised in Chicago, but I was definitely born there. And I stayed in Chicago up until I was 10 years old. They always say, you're not from Chicago. You're not from Chicago. Hell, my family's still in Chicago while you playing. So let's get to my page. What's all this shit on the front of my page? I don't know how to stop all this shit from getting on the front of my page. I'm going to have to learn how to do that. But let me give you guys my TikTok. Now, y'all know I'm still fairly new to TikTok. So this is my TikTok. If you are not following me on TikTok, please hit that button and go and follow me on TikTok, okay? And we will be taking the updates from the state over there. And anything, you know, that you want to discuss or whatever, I will allow you guys to come on the panel and let's talk about it. And even if you don't agree with me, you could talk about it too, as long as you are respectful. She said, I don't have a TikTok. I don't know if you have to have a TikTok to get on there. I'm not sure. She said, baby, it's in you, that mouth. Yeah, it's in me. Because listen, I got aunties that's very Chicagoan, okay? One thing I do like about my family that's out of Chicago, they professional as fuck, but baby, piss them off if you want to. Piss them off if you want to, baby. They professional, but they would give you a nice read and probably even go further than that, all right? So, I think I have that, honestly. I have that, honestly. I really do. We do come from a family of professionals. You know, I ain't gonna say we the Huxtables or anything, but we do come from a family of professionals. All right. But we do got some, you know, we got some street people in our family as well, but not all of them. We ain't dodge bullets in our childhood days. But nevertheless, I don't think you have to have TikTok to follow me. Just click on that link, Renee. Just click on that link. I don't think, do you have to have TikTok to watch somebody? I don't think you do. She said a couple is 2, a few equal 3, several equal 7. So she was shot 2 times. She was shot 2 times, okay? She fired her weapon 3 times and she was shot twice, okay? And this is per the damn autopsy report, all right? So let's do the goal met song because you guys met my goal. I do appreciate it so very much. For those that came in late, you can go back and catch the beginning, but we will be going on TikTok after this. She said, my heart does break for little Carlos. He looks like Ramika, but Ramika should have left well enough alone. Yeah, you know, no, and you know, glad that you even said that. I don't think anybody is glad that Ramika is gone and that her son is left without a mother. I don't think nobody, even though you will have people to lie to you and say such things like, oh yeah, that channel over there, they hate Ramika. No one hates Ramika. We don't even know Ramika. We know a little of Ramika's behavior because we have analyzed her behavior over here. We speak on her behavior, okay? Not her overall person, but her behavior, okay? And her behavior toward Holly was not good. It absolutely was not good. This girl was obsessed and fixated on Holly, and no one can tell me differently. And that's a real thing. There is some women that get obsessed and fixated over you, and it ain't no telling what they will do, okay? So I do believe she was obsessed and fixated over this young lady, and that ultimately cost her life. That ultimately cost her life. So we're going to go on TikTok and we're going to, you know, talk about this on TikTok. So again, let me drop this link. This is for my TikTok. So if you're just coming in, grab that link, join my TikTok, meet me over there. But before we do, y'all, let's dance a little bit, okay? Let's dance a little bit because your girl met her goal today. And I do appreciate you guys for pouring into this live stream. Thank you much. Thank you, thank you, thank you. Yes, again, thank you so very much. I do appreciate it. I dropped the link. If anybody do not have the link, let me know and I'll drop it again. But y'all meet me on TikTok. It may be like 10 minutes. Okay, let me get about 10-minute break and then I will be on TikTok. If you come on my panel on TikTok, just be a little careful because, well, I'm gonna set it to 18 and above. I think if I set it to 18 and above, I may be safe because they're a little bit more stricter than it is over here on YouTube, you know, but I'm going to be myself regardless. So it is what it is. If you get restricted, just get restricted. But I'm going to be myself. However, if you come up, just kind of keep that in mind that there's certain things you can't say. I know so far, though, I've only got hit with 2 things. Well, one, they tried to say I showed nudity. That wasn't true. And the other thing was somebody came on the panel and said the F word for gay, the other F word for gay. Don't use those type of words over there. They get super sensitive or whatever, which I don't think that we should use those type of words on TikTok dealing with this case anyway. But just, you know, just be mindful of that. All right. So I will meet you guys over on TikTok. But y'all hit that thumbs up button for your girl. And I'm going to talk to y'all soon. Thank y'all. Bye now.
Because they can't make $1 without mentioning down one of our names.
Jay!
She kept talking about
We
that
got these
family.
hoes over there about
She kept
bad.
talking about that family. She kept talking
Internet
about that
gangsters.
family. She kept talking about that family. She kept talking about that family. That family. She kept talking about that family. Talking about that family.
These motherfuckers don't be wanting to bless no damn body.
Because they can't make a dollar without me.